Hey everyone. That was actually pretty easy. You're a nice group. Welcome to Beyond Bars. I'm very happy to see you all here. Today's the big day. We're going to move the fence posts on how we think about incarceration. So welcome. A couple of people I wanted to call out in particular. This conference was brought about today, as you probably know, from a class action lawsuit called Judd versus AT&T. And the class counsel for Sandy Judd et al. Is here, and I just want to especially welcome Chris Yautz. So thank you. Thanks for everything, Chris. Oh, I'm Caitlin with the Legal Foundation of Washington. Sorry. I get so excited about everyone else, I kind of forget who I am. I also really wanted to thank the planning committee that's been working for 6 or more months on making today come together, and in particular the staff at the Legal Foundation, Sarah Broomfield and Andrea Axel, who really did a great job pulling this all together. So. And the last fun thing I get to do, I was practicing her title last week. And so I think technically it's something like the Associate Dean of Public Service, but I sort of think of her as the President of Wonderful Things. So please welcome Michelle Storms.
Good morning, everyone. So the short version of my role here is that I'm the Assistant Dean for Public Service Law. And the beautiful thing about having that role, which is kind of a rare role in law schools, is that I get to really be a little bit of the force for public interest, social justice, and social change within the law school. And so when someone like Andrea Axel from the Legal Foundation comes to me and says, we're looking for someone to partner with us to bring together this very important gathering, I get to say, yes, we are 100% behind that. The law school is the perfect venue to be thinking about how we overcome the barriers, the obstacles, the discrimination, the disproportionality that exist in our criminal justice and other systems. And so I am extraordinarily grateful to look around this room and see so many people who are committed to change and to making our systems better, and to know that we're able to convene this here in the law school. So thank you so much for being here. You are so very welcome here. I'm really hopeful that this is going to be a day in which you can not only be inspired and fulfilled, but can actually really, as Caitlin wonderfully said, move the fence post or the needle. I don't remember which analogy it was, but that action comes out of this day, action and change. So welcome and thank you. As is always required, there's 1 or 2 housekeeping things, right? So please, if you've got your cell phones with you, just set them to stun. Don't, have them making noises. The restrooms are down the hall, this end by the elevators. Wi-Fi, hello, right there. There's also pieces of paper that tell you that. So I think that's the basic stuff. So what I get the pleasure of now doing is introducing our first speaker, who is our keynote speaker for this morning. And it really is a special pleasure to introduce you to this young man. Theo Shaw, has a deep and personal connection to these issues and has had to himself overcome many obstacles that he is going to share with you when he talks. But what he's done is managed to turn all those barriers into opportunities so that he can now be a force with his mission for his life and his professional career to do the same for other youth, to give them the opportunities to have their own power, their own space, and to be able to make a contribution to their communities and to society. Mr. Shaw is currently a community advocate for the Southern Poverty Law Center. He's been a fellow with the Youth Justice Leadership Institute of the National Juvenile Justice Network. He graduated from the University of Louisiana. He is law school bound. I'm hoping he's going to come here. And he is a person who, with humility and wisdom and compassion, listens to others, formulates strategy, and then takes action. So it's really a great gift that we get to have him here with us this morning. Oops, there's one of those cell phones not on stun. Okay, but it's going to be all right because it's going to get fixed. So please join me in welcoming Theo Shaw.
Good morning. I'm so excited to be here this morning. Thank you so much, Dean Storms, for that gracious introduction. It's a special privilege for me to be here this morning. I don't actually get a lot of time to actually, wear suits. So when Sarah called me, I was so excited about, flying here to Seattle to speak with people who are committed to these issues. I spent a lot of my time in juvenile detention facilities, in adult facilities, talking with young people, talking with adults about their about some of the issues that they're faced with and some of the challenges they suffer within our justice system. I've been with the Southern Poverty Law Center for almost 3 years now, so my professional career is short, but I made a commitment when I was 17 years old as a person in our justice system dealing with these particular issues. And I made the commitment during that dark time in my life where I was in a jail cell to be a voice for those who I know would to some extent inevitably suffer the same injustice that I suffered. And so I did want to contextualize my comments to follow. But one of the first things I want to say is for the next 20 or 30 minutes, however long you all want me to talk, I do want to be as brutally honest as possible, as rigorously as honest about these issues as I can. And in that approach, if I offend you, then I don't actually apologize because I do want to speak the truth, at least how I see it. And I also want to add that because I'm young, because I'm still sort of forming, like we all are, my remarks aren't permanent. I don't say that in a defense should I say something to offend someone. I'm just saying that I am still developing my voice so that I can continue to be a voice for those in need. And those who are, suffering in our broken justice systems. But first off, I want to operate from the premise that in our justice systems, Black and brown lives don't matter. And while it can be argued that that's true in other in our other institutions, it's especially true when you look at our juvenile and criminal justice systems. And like I said, from the start, my experience, my sort of professional experience with these particular issues is very personal. When I was 17 years old, I was a high school student at Gina High School in Gina, Louisiana. Some of you all are probably familiar with the case of the Gina 6, but I was one of the young men charged in that case. And I remember waking up that morning being sick. I don't know if it was sinuses. I don't know if it was allergies. I say those two because those are the things that I sort of remember and today suffer with. But I remember waking up very sick, and I thought about not going to school, but we had been out of school for a couple of days. So I said, I'll battle it out. I'll go to school. But I got to school, and there had been a lot of, racial tensions going on in the city, in the town, and the school, to a large extent, students were very segregated. And I just sort of felt, it's something about, the environment that I sort of felt. You feel the racial tensions, particularly if you're familiar with the South. And so I got to school and I was sick and, just feeling, the environment. And around lunchtime, there was a fight. And, if you were ever in high school, when students fight, a lot of people want to run to the fight, see what's going on. And so I remember running to the fight, and there just had been a lot going on. I didn't actually see much of what happened. But we went to class, and I was in my English 4 class, and students had just been talking about the event. But then I was called to the principal's office. And when I got to the principal's office, there was a vice president and there was an officer. And the officer began to question me, not about what had happened at the school at lunch, but he began to question me about an incident that had happened about 2 days before school started. And he was talking about an event where me and a couple of my friends, these were other African Americans, we were at a local convenience store, and a white male, a man, maybe a few years older than we were, showed up to the store. And I guess he felt threatened by our presence. And that sort of was predicated on the fact that one of the guys I was with at the store that day had been attacked by this white man and a few of his other grown friends a couple of nights before. So him assuming that we were going to, I guess, seek retaliation against him, he pulls out a shotgun on us. And this is a very white community. Most of the black people who leave Gina usually leave to go serve a prison sentence. And whites pretty much run the city. But he pulled his shotgun on us in fear. And one of the guys I was with, he ended up wrestling the gun away from him. And we all ran home thinking, oh, well, he probably has another gun. So we all went to our respective homes, didn't think much else about the incident because we didn't feel like we were in the wrong. We were thinking, well, this, guy pulled a shotgun on us about to end our lives. And so, we all ran home in fear. And so when we got to school that day and I was in the principal's office, he asked me about that incident. And I, told him that, like what I just told you all, I was at the store and the guy pulled a gun on us. But then he began to read me my Miranda rights after he had already finished questioning me about the incident. And I actually learned, during my incarceration that was probably something that he wouldn't be able to utilize in trial, but he did it anyway. But he walked me out of the school in handcuffs. And I have to say that was the most embarrassing moment of my life. I know sometimes we sit around and, we share stories with each other about your most embarrassing moment. And that's just when those conversations come up when I'm with my peers or with my colleagues. It's just something I never share, although it's in the back of my mind. And he walked me out of the handcuffs and I began to feel like I was a problem. And it was a temporary feeling where I became foreign to myself. I began to sort of feel how they feel about me as a black person as being a problem. And so I ended up going to jail and I was in there, just thinking, I was only 17 years old. So I'm, thinking the whole time, well, this is going to work out. I'm eventually going to go home and, going to finish my high school career. And so the, guard comes to my cell. This is like maybe the same day or the next day. And I'm thinking, oh, well, okay, I'm about to go home, about to get back in school. And he told me that he was charging me with, I was getting booked on more charges, attempted murder and conspiracy to commit murder. And there were so many other charges. And this was for the incident that actually happened at school for something I wasn't even around the other kids who were arrested. And so when we were all in the cell, we were sitting there thinking, well, they're saying we all did this and none of us were even around each other. So that incident sort of led to me spending almost 8 months in a cell with grown adults, 24/7 lockdown. And that had to be the most challenging thing I think I would ever experience in my lifetime. I grew up in a poor community, but nothing was as difficult as when your freedom is being taken away, especially when you feel and know that you're not responsible for what they said you've done. And so I say that to sort of provide context for some of the other things that we're up against as advocates seeking to reform our broken justice systems. One of the things I think we have to think about when we're talking about working to improve the lives of those impacted by incarceration is that we have to, I think, challenge the narrative that criminalizes black and brown existence. We, as people of color, live with this burden, and it's frustrating. As black, it is not even necessary that I engage in a nefarious activity. The sort of narrative tells us, and we see this in our media, we see this in the way that we treat people of color, is that you are guilty qua your existence. It is not even necessary that I even engage in some criminal activity. We see this with the way Barack Obama is treated, by Republicans, and I'd say that in a nonpartisan fashion. We see that when we have, Harvard University professors being arrested at their own homes. We see it in poor communities where we are disproportionately policed and surveilled, not just by the police, but by, it feels, society. And this presumption of guilt is especially true when you begin to sort of look at our juvenile and criminal justice systems. I spend a lot of my time in juvenile detention facilities. I've probably interviewed with the SPLC. I've probably interviewed over 300 youth and adults regarding, our campaigns, whatever the issue may be. And we see it in courtrooms when we drag kids into court in mechanical restraints like shackles. And it's humiliating. It's I don't know. It's just hard to see. It's very hard to see, and it just continues with this presumption of guilt, and the research shows that judges and juries, they continue to hold those prejudices and biases against kids and against adults when they see them in these shackles. And I think as people working on these issues, that is one of the things that we have to tackle. Another thing, sort of in working on these issues, is sort of challenging in ending excessive isolation of young people and adults in our juvenile and adult detention facilities. Again, I talk with kids who tell stories of speaking with themselves, of psychosis, and even wanting to hurt themselves because of how we treat them in our juvenile detention facilities. That is something I think that amounts to torture. And if we believe in the juvenile justice system as a system that is supposed to rehabilitate young people, then I think we have to challenge and ultimately eradicate all of these practices in our detention facilities that seeks to frustrate that goal, that seeks to frustrate the goal of rehabilitating young people. I remember speaking with one kid who was at a detention facility in Mississippi, in Gulfport, Mississippi, in the Biloxi Gulfport area. And he was a kid who identified as gay, and because the detention center didn't know how to sort of house him, quote unquote, house him around the other youths, they subjected him to isolation, and he began to feel like he was the problem. He began to feel, he just began to question himself a lot. But it was his self-esteem. It was him wanting to hurt himself because others refused to see him. They didn't see who he saw himself to be, and so they subjected him to this, harsh treatment. And I count on these detention facility staff to actually be educated and trained in how to deal with certain populations, and they just aren't. They think it's a joking matter a lot of times. I remember speaking with a sergeant at a facility one time who thought it was funny that a kid who had a mental disability, they thought things like that were funny. And so I have to tell these guards, and it's something that if you really care about these issues, that is very frustrating when you see that level of indifference, profound indifference, I would argue, from detention center staff. And so I have to, tell the guard, like, look, the consent decree says that no youth is supposed to be subjected to this practice. for past 72 hours, and they have these kids in isolation, solitary confinement, and whatever other thing that they call it, lockdown, administrative segregation. They try to call it different things to sort of subside the effects. But I spend a lot of my time having to talk with detention center staff about taking young people out of these sort of torture type settings, at least in my opinion. And so I think that is another one of the things that we have to think about, and something I'm certainly committed to eradicating when talking about working to improve the lives of those impacted by incarceration. Another thing really close to my heart on the subject is the state of indigent defense for poor people and racial minorities in our juvenile justice systems. During my incarceration, which I said I was locked up for 8 months, 24/7 lockdown, I probably had one conversation with my public defender during that time. And I know it's due to a lot of reasons. I know particularly in New Orleans, we're dealing with a governor and also legislators who just aren't, there is no incentive for them to fund adequately public defense. And so during my incarceration, I remember just being sort of tired and frustrated with the fact that I was in jail. I only had 8 months left in high school, and I was trying to get out so I can get to school and ultimately get to law school, because around the second day, or like second month or so, I had told myself that I was going to go to law school, that I was going to get out and work on behalf of those who were, would suffer the same injustices that I was currently suffering. And so I would spend night after night just sitting up and reading about the law. And, they would turn the lights off on me. The guards will, it was verbal assaults from the adults. It was mace from the detention center staff, who were just somewhat disturbed by the fact that I was educating myself I was educating myself so that I could help myself get out. And I spent a lot of my time just up reading the Louisiana Code of Civil Procedures, and I began filing motions. And I remember filing my first motion, and it was denied, and I was just so excited. I was excited because they actually responded to me. And although it wasn't, the response I was looking for, it was a valuable lesson for me. I had to learn their language in order to fight the fight that I was up against. And so I filed another motion, and it was denied again. And I was like, man, this is really cool. And, some of the, adults and some of the other people would just, tell me, leave those people alone. Like things will work out. And that sort of passivity is something that I rejected then, and I reject to this day. So I began to file motion after motion after motion after motion until they ultimately responded to me. My bond was set at about $130,000. I had so many aggravated charges. But my bond was at $130,000, if I recall correctly. But once, the media started getting behind the case, and once the public started coming to New Orleans, I was ultimately successful as far as getting my bond reduced. I think I got it reduced to about $80,000 or $90,000. And because, the case was kind of blowing up at that point, the community and just other people were pulling in to help me get out. And as soon as I got out, I was able to, finish my high school credits. I moved to Georgia. Finished my high school career there. I still end up getting my Louisiana diploma because I only needed one English credit. But then after my high school, I came back to Louisiana for undergrad, where I served in student government, continued to learn more about government and about sort of the rules of the game, to say. But that lesson for me, as far as indigent defense, sort of awakened my desire to be a criminal defense attorney and sort of, be a voice for people in our criminal justice system, racial minorities, juvenile offenders, condemned prisoners, and those wrongfully convicted in our justice systems. Another case in point, I work with the Southern Poverty Law Center Louisiana office, and we filed a civil lawsuit against the sheriff there in New Orleans for unconstitutional conditions of confinement, degrading conditions of confinement. There was violence, had been at about 30 to 40 deaths at the prison in New Orleans since Katrina. And so when I started with the Southern Poverty Law Center in 2012, I was immediately sent to the prison where I would, meet with a lot of adults and kids, and sort of, write my experiences after that and be able to, sit down with the attorneys on the following week and discuss with them some of the issues. And although that was a civil matter, one of the chief complaints from the adults was the fact that they weren't hearing from their public defenders or from their court-appointed attorneys. I had one client who literally died waiting for counsel. I had, been visiting this guy for about a year and a half, and he just always had a very bright spirit, never complained about any medical issues. If anything, it was very minor. If he had like a headache, they would give him a pill or something like that, but nothing major. And I remember him talking with me as much as I told him, look, I'm only here for the fact that we filed this civil complaint against the jail. We're trying to address the conditions of confinement, but they would just always, talk with me about the fact that, well, can you call my public defender? Can you give him or her this letter? Tell him to call me. I need a visit. And this guy was, he was offered a plea and he could have got out of jail, but he maintained his innocence throughout the entire time. He refused. He could have taken a plea to even go home, but because it sort of conflicted with his values, he just continued to refuse. And that was not something I could give him guidance on because, like I said, that wasn't a matter I was, helping him with at the time. But I know at the time of his death, he was sitting in there waiting for a lawyer to help him with his criminal case. And I think as far as, working and as people committed to improving the lives of those impacted by incarceration, we have to, I think, be on the ground, be on the phone, be wherever we need to be in social or educational settings, advocating for people, particularly poor people and racial minorities in our juvenile and criminal justice systems so that we can improve indigent defense. Another thing I think is important is assuring a continuum of service. As I mentioned, we filed a lawsuit against the sheriff, and we ultimately got a federal consent decree. The Department of Justice in Washington intervened in the case, and that helped out a lot as far as putting pressure on the sheriff and on the city to actually provide the funding necessary to make sure that the pretrial detainees had adequate medical and mental health services, and making sure the juveniles were protected from the adults, the juveniles who would be charged in the adult system, to make sure that they were separated and that they were safe. And one of the things we have to deal with a lot was the fact that there wasn't adequate services for juveniles in the adult facility in New Orleans. I know since 2005, the United States Supreme Court has been on the sort of trajectory of creating a special Eighth Amendment status for juvenile offenders. In 2005, in Roper versus Simmons, they prohibited the death penalty. In 2010, in Graham versus Florida, they said that juveniles can't be subjected to mandatory sentences for non-homicide offenses. And again, in 2012, in Miller versus Alabama, they applied that reasoning to juvenile offenders for juvenile homicide offenders. And actually this morning, the United States Supreme Court granted cert in a case out of Louisiana where they're going to address the Miller versus Alabama retroactivity issue, hopefully on a national stage. I know our Supreme Court in Louisiana ruled that decision wasn't, retroactive. But the Supreme Court this morning, I was sitting in my hotel room this morning and actually got so excited that they granted cert in that case. But I say that to say that the court in those decisions relied heavily on behavior and neuroscience, the fact that young people are developmentally immature, the fact that they're less culpable than their adult counterparts and more likely to reform. But that's not the narrative we see when we subject young people to the adult criminal justice system. We take young people, at least in Louisiana and in the South. I don't know how great or if things are great here, but I know particularly in the South, we take young people as young as 14 and 15, and we subject them to adult treatment in the adult criminal justice system. And that is, in my opinion, a life sentence. We no matter if they spend 2 or 3 years in jail, when they get out, they're going to be have to suffer so many collateral consequences of having to be in that system that is almost impossible for them to improve as adults. And I think that conflicts with what the Supreme Court has said regarding young people. And so we have to get young people out of the adult system back into the juvenile system where they can have the services that they need to reform and grow into responsible adults. Another thing that I'm deeply committed to is being a voice for those who have been wrongfully convicted in our juvenile justice systems. When I'm not in a jail or when I'm not at a conference, I spend a lot of my time babysitting for Emily Moss. She's the director of the Innocence Project in New Orleans, and I spend a lot of my time talking with them about their cases. Just being around the office, learning as much as I can, and trying to connect with people who have been wrongfully convicted in our justice systems, trying to learn as much as I can from them about how we can improve our broken system. When I moved to New Orleans in 2012, I spent a year and a half. I lived with John Thompson, and for those who aren't familiar with John Thompson, he spent nearly 20 years on death row at Angola, Louisiana State Penitentiary for a crime he didn't commit. He was exonerated, and the Fifth Circuit awarded him $15 million. But then when it got to the United States Supreme Court, they overturned the decision. It was a Brady issue, but the Supreme Court said that John, pursuant to his claims, couldn't prove that it was a practice of Brady violations, aside from his one instance. But I spent a lot of my time with John Thompson when I moved to New Orleans, and we just spent a lot of time just talking about our criminal justice system, like how do we improve, like what's missing. And one of the things that's very close to his heart, and which I share with him, is the lack of accountability and prosecutorial discretion. I know a lot of times there is no adversarial system for poor people and racial minorities in our criminal justice system. A lot of time, because of the lack of funding for public defense, prosecutors are basically serving as judge, jury, and also giving the sentences. There is no investigation on behalf of the public defenders. And for court-appointed attorneys, where there is this lack of resources. And so prosecutors, to a large extent, are determining outcome. And when they are caught withholding evidence or whatever, the misconduct may be, there is a lack of accountability. And that's something that John and I talked a lot about. And so I think we have to continue to advocate for accountability when prosecutors mess up. There was an opinion piece that I would suggest reading in the Shreveport Times in Louisiana I think it was last week, and it was a prosecutor. He's a former prosecutor. He may be in private practice now, but Glenn Ford, who was also exonerated, there's an apology, but and I appreciate that. But still, there has to be some sort of accountability more than an apology if we're serious about addressing the challenges that we're up against in our juvenile and criminal justice system. I'll say this and I'll end on this. As people of color, I think a lot of times working on these particular issues, it is sometimes very difficult when we're in majority white spaces. And I don't say that about this particular conference, because this is great that we are able to have these conversations. But when we are in our workplace, it's difficult because it's easy for the issue of race not to come up when it's significantly important. And I think that in response to any injustice, that silence, verbally or physically, is suicidal and only functions to reinforce and perpetuate the ill. So I share with a lot of people W.B. Du Bois's speech where he talked about agitation, and it's only a paragraph, but it's profound. It's something that I post on my desk in front of my computer, and I see it every day. And he says that some people fear agitation. They say, "Do not agitate, do not make a noise, work." He goes on to say that that such honest critics mistake the function of agitation. A toothache is agitation. Is a toothache a good thing? No. Is it therefore useless? No, for it is supremely useful, for it tells the body of decay, dyspepsia, and death. Without it, the body will suffer unknowingly. It would think all is well when low danger lurks. And if I could theorize it, I would say that is true of the social movement when we're talking about a commitment to improving the lives of those impacted by incarceration. Du Bois emphasized that agitation is a necessary evil to tell of the ills of the suffering. And I think as people committed to working on these particular issues, that we have to say to the world, to our friends, to our colleagues, to our legislators, to our judges, what needs to be said, the uncomfortable truth when it comes to these particular issues. I know myself that I want to be an agitator. If it means that I have to sacrifice some of my friends, some of my peers, then that's going to have to be the case. Because like I said, silence, on the other hand, only perpetuates the ill. My question to you all today is, who are you going to be? A part of the problem and be silent, or are you going to be an agitator? Thank you.
I feel a little bit like we could just stop now and I'll go do what we need to get done. Thank you, Theo Shaw, so much for just your wise words, your grace, your intelligence. I wish that everybody could hear it. I wish they could hear it here and hear it here, and act upon it. And so that's what we have in front of us today, is the chance to really work with this material.